Mr. Wilson Bezwada, as he always does, took us straight into the hearts and the pain and suffering of people. And basically it told us that there is no balm, no relief, no solace coming from these courts. And I was reminded of an encounter that I had with a landless Dalit about 150 kilometers away from Bhopal when I was living in Madhya Pradesh, whose home and family had been viciously and violently attacked by dominant caste members, in order to acquire their land for their own purposes. And when I went there, and I found that I heard about this, it didn't come in the press, someone mentioned to me, so I just went there in capacity. And when I went there, I found that the court complex was only 1 kilometer away from this village where this had happened. And someone I knew through the Judicial Academy was then the principal district judge. And I knew that he was a sensitive judge, very well-trained judge, very highly educated judge, very committed judge, very honest judge. And so without saying any of this to these people, I told them, why don't you, go to the court that is 1 kilometer away and lodge a complaint about what's happened to you. And I'm sure the court will protect you, because that's their responsibility. So he looked at me, recognizing that I am a fool who knows nothing about the real world, and speaking very slowly, as you speak to people who may not understand quickly what you're saying. He said to me, a court is a place where the police forcibly takes you to. No one goes to a court. So this became a new definition of courts, because coming as I do from the legal profession, if you ask any of us, most of us will say, if I ask any of us what is a court, we would say a court is a place of justice where rights are secured and people go to protect their rights. But here was a landless Dalit educating me about the people's definition of a court as a place where you are forcibly taken by the police to be punished, and a place that no one will voluntarily go to. So I have, over the years, shared this with literally thousands of judges and law students across the country. And I've asked them, when will this definition change? And a landless Dalit will say, yes, I've already been to court, because a court exists to protect me. And I would go to court as I would go to a good hospital. If my bones are broken, I would go to a court if my rights are broken. How and why? And clearly that episode is enough to answer the question, are courts delivering justice for the caste marginalized? Sadly, as no, they're not. But we have to ask ourselves, how do we understand this problem? How do we frame it? And what are the different indicators or matrices by which we can answer this question and seek a solution? So first of all, I'd like to begin by saying that we should understand that we are in a moment of change, a process of change. We can either look at the system as non-functional and failing, which it is, or we can understand that the legal system and the judicial system is a very ancient system, starting from ancient times through the feudal rule of Maharajas, and then Mughals, and then coming to colonial times. Very quickly summarizing this period. In fact, I generally, from a legal point of view, structure it into the Raja era, the Raj era, and the Swaraj era. Unfortunately for us in the Constitution, these courts continued from the Raj era from the Raja era to the Raj era to the Swaraj era with almost no structural constitutional change. The only new court is the Supreme Court of India. So when we look at the change, I was reading the other day a 1957 article by Professor M.N. Srinivas, who, as we all know, is a right-wing sociologist, quite casteist himself, one of the founders and fathers of the discipline of sociology in our country. So this is from that point of view, a very, very conservative source. I'm going to read 3 or 4 lines from that article about the legal system. Professor Srinivas says, it is widely held that the civil and penal codes introduced by the British over the subcontinent of India took away much power previously exercised by caste panchayats. The British also introduced a new principle of justice, namely that all men are equal before the law, and the nature of a wrong is affected by the caste of the person who is committing it, or by the caste of the person against whom it is committed. It is necessary to emphasize in this connection that the use of law courts by some peasants did not put an end to caste panchayats. The peasants made use of both systems of justice. Traditional panchayats, caste as well as village, this is in 57, not very different now in some parts of North India, are still functioning in many parts of the country. This fact is in all schemes for the revitalization of panchayats and so on. Now, what I want to say, I've ended the quote, is that we must understand that the Constitution of India after independence started a process of completely changing the role of courts, principles of justice, in a very revolutionary manner, in a manner that would from protecting the powerful against the powerless to protecting the powerless against the powerful. But it was not until, I believe, 1964 that we had for the first time a Chief Justice of India who had not been appointed by the British as a judge when they were colonial rulers. And they still, these colonial traditions, using the words lordship, using the words, pleads, using the word petitions, rather than complaints or remedies. These kind of traditions where the people are are pleading before the majesty of the law is still continued in our country. So we are now in a transition where we have, as Professor says, referring to the peasants of the system, he refers to 2 systems of justice in the country. One, a feudal system, and the other, a constitutional system, in reality, not in formal legal terms, but within those legal structures, in those buildings, actually 2 systems of justice are struggling against each other. One I would call Savarna justice, and the other I would call Swaraj justice, based on the Constitution of India. And when I say Swaraj, I mean individual freedom, liberty, equality, fraternity, the values of the Constitution. And it is in this struggle, in this context, that we must see that that there is no justice, as both Professor Kancha Ilaya and Mr. Wilson Bezwada said, for the caste oppressed or the caste marginalized in our country. I should just go back to that story that I said I related from Madhya Pradesh, because when these people, these landless Dalits saw that I was very disheartened when they refused my suggestion, they rejected my suggestion that they should go to court. They took pity on me and they said, we'll find a solution for you. So they said, look, they asked one of them, bring a piece of paper and a pen. So someone brought a piece of paper and a pen, and they told me, please write a letter in the the strongest English you can to that judge you talked about, and give it to us. We will take it to the police guards in front of the courts. We will give it to them and say, this is a letter for the judge, and we want you to write it in very hard English, because we do not want the policeman to be able to read the letter, because then he will may not take it to the judge. So he should not understand the letter. It must be to the judge, and then hopefully he will take it to the judge. Judge will see it. It's from you, And if he is really a nice man, like you say he is, then he will call us. So let's try that. So I said, fine. I wrote a very toughly worded letter, notwithstanding hitherto, without reference to, with respect to all those technicalities. And I gave the letter to this judge who I knew, but I did not tell them I knew him. And then I said goodbye and I left. A couple of days later, I called them and I said, what happened? They said, we took it to the policeman. He tore up the letter without even reading it and threw it into the on the road and said, "What do you people think? You're going to see the judge and you're going to give a letter to the judge? Get lost before I beat you up." So he said, "This is what actually happened." So you can see that these institutions are still, as both Professor Kancha Elaya and Mr. Wilson Bezwada said, very distant and very inaccessible to the oppressed castes. They have to encounter caste prejudice at every level. When we say courts and judiciary, we have to mean, and we do mean, all elements of the system, not just the judge, but the lawyers, the staff, the officials, other officials of the court, related to the court, the whole industry that works around the court, making money and a living out of protecting justice. So this system is still hardly changed, and to a large extent, I have found in my experience working across the country that these courts are a mirror to society. So courts in Kerala are the least inhospitable to the caste oppressed, more accessible to the caste oppressed, because Kerala as a society has evolved more on the path to democracy than courts in Madhya Pradesh or in Bihar and so on, where they're still extremely feudal. So therefore, we must understand that, as Srinivas himself says, conservative man, that we are in a situation where two systems of justice, Savarna and Swaraj justice or constitutional justice, are clashing with each other. In this context, I feel that we have to look at 3 or 4 aspects of the judicial system as important matrices or indicators to understand its attitude to the caste oppressed. One is what Mr. Wilson Bezwada raised, which is what value does it give to the suffering of the caste oppressed and the poor? What value does it give to manual scavenging, to violence against the poor, caste violence against the poor? We recently had a discussion on Hathras, where I was making the point that the brutal, inhuman rape and murder of the young girl and the brutal and inhuman destruction of her physical remains after her death are really part of the old traditional Savarna idea of justice, where raping Dalit women was part of their tradition. And in fact, those women were expected to be handed up to them to be raped. And now that the constitution has come, has made it a little more difficult for them, they are reacting by increasing violence. Untouchability has morphed into atrocities, as in other countries like racism. The Civil Rights Act increased physical attacks against the African Americans, and a whole series of attacks, which still continues, racist attacks, because the stronger the protection of the law and the greater the opportunities for the race oppressed or caste oppressed to protect their rights, the greater the backlash. In fact, in this article, as many of you may have read it, Srinivas' central argument is that actually the introduction of greater rights for the caste oppressed has increased casteism in India because of the backlash of protection of the rights of the caste oppressed, almost making an argument that maybe it was not a good idea to do it, which of course I would strongly disagree with. So we have to look in specifically at not only the as I said, first the question, what value does the system give to the most urgent, most burning concerns of injustice of the poorest in the country, and the answer, as we know, is very little. So you have Ambani's brothers' dispute being directly resolved by the Supreme Court with high level of priority. That kind of priority usually comes only when poor people have to be given the death sentence. Then the courts meet and ensure that the time schedule is maintained, and revenge is exacted from those convicted, who generally happen to be very poor people. So I think this is at the heart of our democratic change, and this takes us to Professor Kancha Elaya's point. How do we? What is our sense of morality? Morality is a system of attributing value, also, of what is important and what is not important, and what is of greater value and what is of less value. So an assault on the humanity of a human being, merely because that person is a human being, regardless of the caste of that person, should be of very high value. And the absence of that value, Professor Kancha would tell us, is an indicator that we do not have an appropriate and strong sense of spiritual morality underlying the judicial system, which is why it does not value the suffering of the oppressed. Going beyond that, I would say that specific, and I'll finish in now, because we are almost at 6:30, and I wanted to end the session on time because some people will be joining for the next session. But we'll have another follow-up on the more technical aspects of this question, looking at it from the internal justice point of view on a future date. But if I were to look at the main provisions made by the Constitution in favor of the caste oppressed, which are, according to Srinivas, are provoking the upper caste into backlash of violence against the caste system, and that is not being defended by the courts, because they don't believe that there is any injustice when the old morality, the Savarna morality, is applied in society. These are, let's say, one person, one vote, universal adult franchise, and the very valuable vote, equal vote that was given to every person in this country, regardless of caste, regardless of wealth, or regardless of region or background. Unfortunately, in these many years, the judiciary has not given its due importance to the right to stand for elections, and the jurisprudence says actually that we do not have a fundamental right to vote, which I think is wrong. The same standard has been applied to reservations. There have been many interventions, including putting a 50% cap on reservations, which Justice Chinnappa Reddy, in his biography, in his autobiography, or a book on the Supreme Court on the Constitution, called "The Constitution, Its Summits and the Court and the Constitution, Summits and Shallows," Justice Reddy says that this 50% limit on reservations is unconstitutional, and so the judiciary has gone outside the Constitution to limit reservations, to bring in a creamy layer, to dilute the provisions as envisaged in the Constitution, which in turn has had a slowdown effect on the very powerful tool that the Constitution has put into our republic, into its administrative structure, namely reservations. Another very important area where we can see what the judiciary has done, played a very important role, is in the area of religion and law. There is a 1922, I believe, Privy Council judgment, four-judge bench judgment, in which the Privy Council looks at the way the Hindu law on creating endowments and creating mutts, and these temples and these religious institutions, by encouraging and protecting the donations made by rich people to these temples. They look at that whole structure. The document which was by Justice Amir Ali, who was the first Indian judge to be a Privy Council judge, he writes there very clearly in the Privy Council judgment that the purpose of this institutional framework in law to support Hindu religious institutions is to advance the mission of bringing the native Dravidian population under the of the Aryan religion. So we can see that the judiciary has consciously protected the framework for bringing the oppressed communities who are not part of the Indo-Aryan Brahminical tradition under the control of the Indo-Aryan Brahminical tradition, and thereby actually taken a line which is inimical in terms of practical theory and practice and theory towards the interests of the caste oppressed. The number of judgments of the Supreme Court have given priority to organized religion and particularly to priestly religion, and has not given the protection of Article 25 right to religion to small belief systems typical of the oppressed castes, of the marginalized castes. And so there has been a strong bias towards organized religion, priestly religion, and within the Hindu religion, Brahminical religion in many of the judgments over many years of the Supreme Court. So whether it is in terms of voting, whether it is in terms of reservations, whether it is in terms of facilitating a program of proselytization and conversion of oppressed caste Hindus into the Indo-Aryan or other Brahminical or other religious systems, and whether it has been in terms of upholding the social welfare system and ideal justice. In all these areas, I think the jurisprudence that has been developed is very much against the interests of the caste oppressed. Lastly, I would say in terms of the internal culture of the courts, there is need for, as both the earlier distinguished speakers pointed out, there is need for a fundamental cultural change, and that can only come when the judiciary becomes more representative of all the people in the country. Today in the Supreme Court, there is only one scheduled caste judge, there is no scheduled tribe judge, and there is, to my knowledge, there is no Avarna OBC in the Supreme Court. So whereas, in fact, these judges from these backgrounds should have been the vast majority of the judges of the Supreme Court. We are going into the 8th decade of our independence, and we are the voices of the vast majority of the people of this country, and their ideas of justice and their concepts of justice are not represented. In conclusion, I would say that as against the emphasis of Savarna ideas of justice and colonial ideas of justice on order over law, over justice, order must prevail, which means the existing system must be continued. As against that idea, I have always maintained and discussed with several of you that the Adi or Avarna idea of justice is located primarily in relief for suffering, relief for injustice, based on compassion and based on friendship and fraternity and kindness, and protection of not only human beings but all of nature, because these ideas of justice recognize the strong interdependence between human beings and the rest of nature. So we have also got to rethink the ideas of justice that we have inherited from feudal colonial times, and we need to ensure that the ideas of justice of the common people of this country find its due place as the guiding idea of justice of the courts of India. So from access to ideas of justice for a whole variety of reasons, I think there can be little argument that the courts of India are still not able to deliver justice to the marginalized castes. And the struggle between, as Mr. Srinivas said, between two systems of justice, one of the privileged dominant caste, and the other, the constitution as the voice and of the common people of the country. That struggle still continues, and we will have more opportunity to discuss a program of action to take this forward. And I would like to thank again the panelists for being here, and thank you, Mr. Vidyut, for giving me this opportunity.